Hi, good morning, everybody. I hope you're all well and good. And today is Friday, and welcome to Fortis Friday series. Our topic today is Introduction to Trusts. Just a bit of housekeeping. Please keep your audio on mute and do not switch on your video. If you have any questions during the presentation, please type them into the group chat, and Patrick, our presenter today, will address your questions after the presentation. For those of us on Facebook, please just type into the chat as well, and we'll do our best to answer as many questions as we can. Before we go on to the today's webinar, I'll just briefly share with you what Fortis Law does, our two main practice areas that we have. Yelin, can I just have the next slide, please? Yes, our two practice areas, very clearly, very simple, the private client practice group, as well as the corporate client practice group. Within the private client practice group, we do lots of wills and trusts, estate planning, advanced care planning, which includes things like your lasting power of attorney, real estate, of course, and family law, crime, and do criminal law as well. On the corporate client practice group, our team of lawyers handle lots of commercial and personal litigation cases, as well as debt recovery, very, very important for companies these days. Of course, employment issues and challenges as well. So for the next slide, please, Yeling. Today, we're going to talk about, our speaker, he will be talking about introduction to trusts. The areas that he'll be covering will be things like, what is a trust? What are the key parties involved in a trust? Benefits? Any downsides perhaps? The common types of trusts that can be done, and how to create a trust. And Patrick, our speaker, Patrick Tan, he is a very experienced speaker, and he's the founder and CEO of Fortis Law. And he has been practicing for close to 20 years now, lots of experience, and today's session will be a very interesting one. So without further ado, I'll just hand this over to Patrick. Thanks, Patrick.
Thank you, Jacqueline. Good morning, everyone. Welcome to this morning's webinar. I will be sharing what I know about trust over the next 30 minutes with all of you. If you have any questions, please type it into the group chat, or you can ask on Facebook Live. Okay, I will try to answer all your questions. Let me share screen first, all right? Okay, can you hear me loud and clear and see my screen? If you can you type 1 in the group chat so that I know you can hear me and see the screen? Just type 1 in the group chat. Thank you. Thank you, everyone. Okay, so without further ado, let me start the webinar. I'm going to spend the next 30 minutes to share with you a broad overview of what trust is all about. Of course, it will be impossible for me to share everything in detail about trust in 30 minutes, in fact, not even in 3 days. But what I will do is to give you a broad overview of what trust is, and what are some of the reasons why people do trust, and what can trust do for you, right? And whether trust is as expensive, as many people think. All right, so I will share some of these ideas with everyone, and hopefully you have a good understanding after this webinar, and that you will consider having a trust put in place. Maybe this is a good time also to clarify some misconceptions that many people have about trust. I've been doing this for many years now, so I work with people from different industries and about trust, to do trust. So one common misconception that I come across is that, people always think that trust is for somebody very rich, when people set up trust fund or family offices and all this, they think that trust is something for the rich and famous. Now, let me share with you that this is a common misconception, but it is a misconception. It is not true that only the rich and famous can have a trust. All right, there is no law in Singapore that says that you need to have like $10 million, $20 million before you can have a trust. Actually, if you look around us in Singapore, there are examples of trust, everywhere, right? If you look around later on, I will share with you, trust is more common than you think. All right, so it is not something that only the rich and famous can have a trust set up. Okay, and it is also not as expensive as many people think in terms of setting up a trust, right? So a lot of people think that, oh, you need to have a lot of money to set up a trust because a trust is very expensive to manage, to set up. Actually, that is also a misconception, right? Just to give you one example, right? So for parents with children in Singapore, right, actually there is already a trust set up for you and your children. We call it the Child Development Account, CDA. This is an account that the government actually asks parents to set up when you have children, right? This is an account where the government actually gives money to parents with children, a dollar to dollar matching. This is for parents to use this money for vaccination or for whatever specified purposes for the children. So parents out there, you would remember that there are all these accounts, monies being given to you for your children, right? I think the first child is 5,000, the second child I think is 8,000 and 10,000, so on and so forth, right? This is an example of a trust account, right? And parents, being the joint account holder with the child, is the trustee of this account. The beneficiary is your child, your children, right? So actually, trust is more common than you think, right? More common than you think. And there are so many other examples in Singapore to show you that actually trust is everywhere. So I've highlighted CDA and also some of these religious buildings, like churches, temples, malls, and all this. You'll be surprised to know that many of these buildings are actually held by trustees. And who are these trustees? Basically, the devotees of this religious organization. They are the trustees. They are the devotees who are basically holding the title, the legal ownership of this religious building for the benefit of the devotees. And why they do this? Because it is their religion. They want to do something for their religion, right? So you will be surprised to find many of these churches, temple, malls, and clan building, clan building are actually held by trustees. So actually, trust is not new. It is not something that the government or the law or somebody has created in the last 10, 20 years, created by the private bankers and whatnot, right? Trust has been around for many, many years. All right, many, many years. In fact, just to give a bit of a history about trust, trust, from what I recall, actually goes back as far as like at least 500 to 1,000 years ago, right? I cannot verify this story, but I read it somewhere that this whole idea of trust came about when the Crusaders, in medieval Europe, they were called upon to fight the Holy War in the Middle East, right? So we all know about the Holy War between the Christians and the Muslims. So when they go and fight, many of them actually do not make it back alive. So before they leave their home country and go to the Middle East and fight the Holy War, they would tell their neighbors, say, I am going to fight the crusade. Can you look after my estate, my properties, my monies on my behalf for the benefit of my spouse and my children? And if I do make it alive, if I do make it home alive, and you return the estate, the property to me, right? That was how this whole idea of trust actually came about, right? I cannot verify this story, but it was since then, I mean, according to this story, this was how trust actually came about, right? So as you can see, trust is all about, entrusting your asset, your property to another person, to manage, to hold the ownership of this asset for the benefit of another person, for whatever reason, right? So it is a very interesting and yet important concept, idea, that can actually be very helpful in many situations, right? So this whole crusade, holy war story was how this whole idea of trust was born, was conceptualized. Now, if you understand this concept, about entrusting your asset, your hard-earned money, your property to another person, to look after to look after it for you, to manage it for you, for the benefit of another person, or even for yourself. How powerful is that concept? You can already imagine the different situations that you can actually imagine that a trust can be very useful, right? So over the past 1,000 or 500 years, trust has of course evolved, right? Evolved especially in the common law world. Sorry to bore you, but I have to share this history and this context with you so that you understand, you can appreciate, right, the flavor and the why trust is so interesting, so powerful, and why I am so deeply infatuated, I say, with trust. I would say that not many lawyers in Singapore are really into this area. I happen to be one of the few who are actually very interested in this area. Because trust, from certain perspectives, can be quite technical and boring, but I like this kind of stuff, right? So over the past hundreds of years, trust has evolved, right? Especially evolved to what we know of trust today. And trust has basically evolved, especially in the common law world. Okay, what do I mean by the common law world? In this world, right, we are essentially split into two types of legal systems, the common law world and the civil law world, right? Of course, some will argue that there's actually a hybrid, like a bit of common law, a bit of civil law, right, in some countries. But generally speaking, our world is split into two types of legal systems, the common law legal system and the civil law system. So trust has evolved a lot over the past few hundreds of years in the common law world, right? Which countries belong to the common law world? Countries like Malaysia, Singapore, and Brunei. In Southeast Asia, we belong to the common law world, right? And countries like Thailand, Laos, Vietnam, Cambodia, Indonesia, Philippines, they belong to the civil law world, right? In North Asia, so we have Taiwan, Japan, Korea, China, they belong to the civil law world. In Asia Pacific, Australia, New Zealand, they belong to the common law world. And if we talk about Europe, right, Britain, right, UK is a common law jurisdiction, and continental Europe, they belong to the civil law world. So Germany, France, Belgium, Scandinavia country, they belong to the civil law world. And of course, we have the Sharia law world, right? So besides the common law, the civil law, we have the Sharia law also. So many countries in the Middle East, they have Sharia law legal system, right? So of course, we have the Americas, we have the US, Canada, they belong to the common law world, right? And then other countries in South America, they belong to the civil law world. So basically why I say this is because the different legal systems, I mean, they have very different laws, right? And different ways of actually administering the law, okay? So I do not want to go into the detail because that will put you to sleep, right? Safe to say that, trust is a concept, that has been developed over many years within the common law world. But having said that, in some civil law countries like China especially, trust is also gaining popularity. So many years ago, when I went to China to give talks and share what I know about trust, it was at its infant stage. Many of my clients in China, they were wondering what this concept is all about, and they find it very interesting, right? Nowadays, if you were to go to Shanghai, you go to the major first-tier city, you can see many trust companies being set up. Trust is very established in China already. So civil law countries are also adopting this whole concept of trust because they find it a very powerful idea and a very useful structure to have. All right. So this is just to give you a brief history and a brief context of what trust is. All right. So I hope that you are not asleep by now. So I would like to go into what exactly is a trust is. Okay. So if you have stayed with me so far, you would have a clear idea what a trust is already. It is all about, okay, putting all the legal jargons aside, it is all about entrusting your assets to another person, to hold it, to manage it, this asset for the benefit of another person. So we are looking at three people here, right? First thing, the person who owns the asset. This person is called the settlor, right? The person who owns the asset is called the settlor. Settlor, right? This settlor settles his asset. The asset can be a property, can be your jacket, can be your handphone, can be anything, right? You basically settle this asset or transfer the ownership of this asset into the hands of this person called a Okay, no prize for guessing. A trustee. All right, a trustee. All right, and the trustee will hold the ownership of this handphone, this asset, for the benefit of another party, another person called a beneficiary. So we have a settlor, a trustee, and a beneficiary. These are primarily the three key parties in a trust structure. All right. Of course, we have other parties, but they are optional. Like we can have a protector, we can have a settlor substitute. You know, these are extras. We can have advisors. You know, so on and so forth. But to have a trust, right? The three key parties are the settlor, a trustee, and a beneficiary. All right. These are the three parties in a trust. So trust is a structure. Trust is a legal structure, right? That allows a settlor, that allows somebody known as a settlor to create, that allows this settlor to create and transfer the ownership of what he has, this asset, trust asset, we call it, into the hands of this person called a trustee, who will then be entrusted with this asset to manage it, to administer it for the benefit of a person called the beneficiary. Okay? So that's all to a trust. Don't need to overcomplicate, you know, this is what a trust is. One thing I like to do is to simplify very technical, presumably complicated stuff into easy to understand manner, so that everyone can really use this structure, right? Sometimes, you know, people don't want to know about trust, or don't like to use trust, or don't, because they do not know what a trust is. And many people tend to complicate this whole idea of trust. And I don't like that. I like to make it simple to understand. Right? So what I'm going to do in the next 20 over minutes, 25 minutes, is to explain what a trust is, who are the parties, the benefits of having a trust, what are some of the common types of trust in Singapore, and how do you actually go about to create a trust instrument. All right. So in the next 25 minutes, I will seek to cover all of this. And before I forget, actually 5 years ago, I've written a nice article called Common Types of Trust in Singapore. You can actually download this article on my law firm website, right? So I've written an article, very easy 2-page article that you can download on my law firm website. So after this webinar, please go and download this article to have a sort of a better understanding in case you cannot remember what I shared. All right. Okay, what is a trust and who are the key parties? All right, a trust is created, as I mentioned earlier, when a person gives property to another person to hold for the benefit of a third person. So a trust is a legal way to hold and protect your assets for the future. Actually, okay, I mean, like trust, down here I put is to hold and protect your assets. Actually, asset protection preservation is only one of the many reasons why somebody would create a trust. All right. So I've explained earlier who is a settlor, who is a trustee, who is a beneficiary. These are the three key parties in a trust relationship. All right. You may ask me, rightfully, why bother to go through the hassle? It sounds unnecessarily complicated. I will explain that in the next few slides. Why trust is so powerful. I hope that by hearing the history just now about how trust came about, you can already appreciate why trust is so important. Remember the crusade, the holy war. You know, a lot of the soldiers, you know, they went, you know, they were going to the Middle East to fight, and they were concerned that, you know, and then at that time there was no aeroplane and all this. You can fly there, fight, and then fly back, you know, right? All these journeys take years. You know, when they fight, you know, it may be 10, 20 years before they come home, if they even come home. Many of them don't come home. So during these 10, 20 years, you know, they have to entrust their assets, their gardens, their farms, you know, their properties to somebody who will manage it for them, who will look after it for them, you know, when they are away fighting the war, the holy war. So you can already see from this story why trust is so important. As the name suggests, trust. You trust somebody to protect your asset while you are away. This was how actually, if the story is correct, how trust actually came about. So you can already see why trust is so useful, right? Right? To manage and protect your asset in the event that you're no longer able to. Okay? So this is the origin Again, I say I cannot verify the story, but this is the origin, I would say, if the story is correct, how trust came about, right? Earlier on, I talked about transferring, settlor transferring or vesting the trust assets into the hand of a trustee, right? I use the word ownership fairly loosely, but this is the point where I want to share with you what ownership is all about. When we talk about ownership, all right, this may be a bit boring, but please bear with me. You need to understand this fundamental, right? I mean, layperson, we talk about ownership of a jacket, ownership of your handphone, ownership of a laptop, ownership. When we talk about ownership as a lawyer, there are two types of ownership that we talk about: legal ownership and beneficial ownership. There are always two types of ownership in every asset that we have. All right, legal ownership, meaning who legally owns this asset. For real estate, you can check your name. If your name appears on the title deed, you are the legal owner of the property, right? If your name appears on your bank account statement, you are the legal owner of the money in the bank account, right? That is straightforward. And then we have this type of ownership called beneficial ownership. Beneficial ownership, as the name suggests, who benefits from this asset? Who is the actual person who actually enjoys this asset? Now, beneficial ownership is not reflected on some documents and all this, but it doesn't mean that this person who enjoys the benefit of this asset is not an owner. He is an owner, she is an owner, albeit a beneficial owner. So for every asset, to keep things simple, there are two types of ownership: legal and beneficial ownership. All right. So when we talk about a trust, we are talking about a settlor, the owner of this asset, transferring or vesting, to use a sexier term, vesting the ownership, these two types of ownership of this asset into the hands of the trustee, who will then manage or administer, right, the beneficial ownership, the benefits of this asset for the benefit of the beneficiary. All right. So we are talking about splitting the two types of ownership in the hands of the trustee. So the trustee, on one hand, right, has been vested with both the legal and beneficial ownership of this asset. On the other hand, this trustee is not enjoying the benefits of this asset. What this trustee is doing is that he is holding the legal ownership, but administering the benefits of this asset for another person. All right. Going back to the earlier example that I shared with you, the crusade. So this guy, you know, before he leaves for the Middle East to fight the Holy War, you know, he talked to his neighbor. He said that, bro, I'm going to fight for 10, 20 years. I may not come back alive. During this period, can I transfer my farm, my orange farm or whatever, potato farm, my house to you? So you will hold it. You are the legal owner. But of course, you don't get to eat the oranges and the apples or the potato in my farm. Can I trust you to hold it, manage it for the benefit of my children and my wife? So in other words, you can help me to own it, but really the benefits of this estate, the farm, the oranges, the potatoes, you pluck it and let my family eat. Okay, can I trust you, bro? Can you do that for me? I have no money to pay you, but maybe I can give you some oranges, potato to eat also. Because you know why? I am going to the Middle East and fight for our relationship, right? Can you help me out? The neighbor say, okay, bro, don't worry. Just go in peace. I will manage it in accordance with your instructions, right? So what this tells us is the trustee is holding the legal title to these farms, right, and these properties, but he is not going to eat the potato and the orange and the apple from this farm, right? He is going to pass this potato, orange, and apple to the seller's spouse and loved ones, right? So basically, he's not enjoying the benefits. He is holding this benefit for the person, the settlor's family. So you can see in the hands of the trustee, right? The trustee, the two types of ownership is split up. On one hand, the trustee is holding the legal ownership. On the other hand, he is not enjoying the benefit, right, of this asset. The benefit, he is handing it over or administering the benefit for the benefit of the beneficiary. So really, this is the takeaway that you need from this webinar. This is what trust is all about. All right, in 5-10 minutes, I already explained to you what trust is fundamentally all about. You know, law students take a year or two to learn this. You have gotten it in 10 minutes. Really, this is really what trust is all about. Okay, so far so good. So let me move on. Now, why set up a trust? Like I said earlier, you may ask me, Patrick, this sounds like unnecessarily complicated. Why do we even need to have a settlor, vesting the ownership of the asset into the hands of a trustee to basically administer and manage the benefits for the benefit of the beneficiary? Why bother? So I have listed some reasons here, important reasons or primary reasons why people set up trust. Succession and estate planning. All right, family wealth planning for special need children or those who cannot manage finances. Confidentiality and banking secrecy law. Charities, corporate usage. I am sure you have heard of REIT, R-E-I-T, and unit trust. These are examples of trust, but it is used in a corporate context where the underlying mechanism, underlying structure is actually in trust. So if you buy unit trust, if you are an investor, you buy unit trust. Whoever holds the unit is this person called the trustee. So you have your HSBC trust, you know, all these corporate trustees. What they do is that all these units are vested into the hands of the trustee. The trustee holds these units for the beneficiary. Who are the beneficiary? The unit holder like yourself. No? All right. And then we have another reason, very popular reason why people do trust is called wealth and asset protection. All right. And then we have tax mitigation saving. This is especially the case in Singapore prior to 2008. You know, in 2008, February 15, right, we actually abolished estate duty in Singapore. Dead man tax, that's what they called it. Before that, in Singapore, we have estate duty. At that time, in 2007, the estate duty rate was 5%. 5%. That means when you die, the government actually tax you 5% on both your movable asset, meaning your CPF, your cash, your insurance, and 5% on your real estate, also 5%. But to be fair to our government, at that time, there were certain exemptions granted. So for movable assets, the first $600,000 was exempted. Anything above was taxable at 5%. For real estate, the first $9 million was exempted. Anything above was taxable at 5%. Right? So you can imagine, for the very rich in the past, you know, when their good class bungalows were worth $50 million, $30 million, only $9 million was exempted. If your good class bungalow was $30 million, that means $21 million was taxable at 5%. That is a lot of money. So what some of these wealthier people did in the past, right, was to transfer ownership of their good class bungalows into the hands of a trustee, right? And for the trustee to manage these bungalows for the benefit of the family. So when you do that, you are no longer the owner of the good class bungalow. And if you are no longer the owner of this bungalow, this asset, you cannot be taxed on what is not yours. So that is a legitimate way of saving some estate duty. Not some, actually quite a lot of estate duty. But since 2008, we have abolished estate duty in Singapore, and in Hong Kong, Malaysia also follows suit. This reason is no longer a main reason or a compelling reason now for people to trust. And then investment. So these are some of the key reasons why people actually set up trust. All right. So I can share with you so many real cases that I've done before, you know, just to illustrate trust. Maybe just let me share one or two with you so that you understand why trust is so powerful. All right, so we talk about succession and estate planning. Basically, whatever asset that you vest in the hands of a trustee, they will not form part of your estate. Meaning that even if you have a will, your will cannot include these assets that you have put in a trust right now. Of course, to complicate matters, we have this thing called testamentary trust, meaning that your trust only take effect when you die. When you're alive, your trust doesn't take effect. But we also have this thing called living trust, meaning that you set up a trust when you're alive. It takes effect when you're alive. And if you have set up such a trust, whatever assets that you put inside a living trust will not be part of your estate when you pass away. In other words, your will cannot include this asset. Now, your question is, why bother setting up a living trust? Again, for many reasons why people would want to set up a trust when they're alive. All right. Now, let me illustrate this point with a real case. So many years ago, about 12 years ago, I think 12 years ago or 13 years ago, so this Singaporean guy came to me, said, Patrick, I want to set up a trust. I have a semi-detached house in Geylang. You know Geylang, right? So he has a semi-detached house valued at about $3.5 million. He wants to actually transfer the ownership of this semi-detached house into a trust. So I asked him, bro, why do you want to do that? You know, he said, you know what? Currently, my semi-detached house in Geylang is being used as a temple. You know, if you go to Geylang to eat your supper and all this, right, you may come across some of these semi-detached houses being used as a temple, a Chinese temple, right? So he happens to be the temple chairman, all right? Temple chairman. So this guy is a fund manager, is a wealthy fella. He is the temple chairman. So he has kindly allowed his temple or his devotees of the temple to use his semi-detached house as a temple, of course, with the necessary permission obtained. So I say, okay, but that doesn't explain why you want to do a trust. That doesn't explain why you want to transfer your real estate into a trust. He said that, you know why? The reason why he wants to do this, I said, why don't you transfer when you die? You can always put it in the will. All right, put it in your will to say that when you pass away, you will give your semi-detached house to your temple, right? Why do you have to do it now? And he explained that although he is a Taoist, he is the chairman or president of the temple, which is an association. His immediate family, his spouse and his children, they are all Christians. Can you believe that? I mean, he is the temple Chinese, he's a Taoist, but his spouse and his children were all Christians. So he has a strong feeling that if he doesn't do anything about it, his immediate family would actually not allow the temple to use the semi-detached house as a temple after he has passed away. So, and the reason why he does not want to include this gift in his will, to transfer the semi to his temple in his will, is because he doesn't want to create any more unhappiness. Imagine if the family were to read the will and say that, I have to give the semi-detached house to the temple, that may create unhappiness. So he would rather do something when he is still alive and take this semi-detached house out of his estate, out of his will, all right, when he is alive. So that is his fundamental reason why he wants to do a trust. So after talking to him a couple of times, I could finally understand his need. So when people set up a trust, there's always this phase, what we call fact-finding phase, where we really need to understand the why. Why does a client want to set up a trust? Then we can tailor solutions for our clients, right? Because there are so many options, so many trust instruments that we can offer to our client. But it is important for us to first understand their needs, their concerns, before we can customize a solution for them. So once I have understood that, of course, I prepared Trustee. The Trustee took a couple of months to prepare. It's fairly complicated. So I have also arranged a few trust companies. You know, in Singapore, we have these professional trust companies. They are all professional, licensed trust companies, licensed by our MAS. So if you go to MAS website, you can see more than 60 licensed trust companies regulated, right, by MAS. These are professionals who actually can come in and act as your professional trustee, right, for a fee, of course. It's not going to be free, right? So these are professional, highly regulated, not easy to get a license. So I arranged a few. Client selected one who actually agreed to charge him a fee of $6,000 a year. So every month about $500 to act as trustee of the semi-detached house. In other words, to act as the legal owner. The legal owner. So if you do a title search on the property, you will see the trust company being reflected as an owner, bracket trustee. And who is the beneficiary of this trust? It will be his temple, of course. So who is the settlor? Is my client, the owner of the semi-detached house. So it took some time. We finally executed the trust deed, right? And then we also transfer the ownership, of course, to the licensed trust company, who would then manage the semi-detached house for the benefit of the temple for 100 years. Why 100 years? Because in Singapore, under our trust law, right, our trust actually has a validity period, right, of 100 years. After 100 years, the trust will collapse. The trust asset will be vested onto the hands of the beneficiary. In some other countries like Hong Kong and BVI, their trust laws actually allows for perpetual trust, meaning that trust can last forever and ever. In Singapore, our trust must end by 100 years, in 100 years. Okay, so there are a lot of arguments whether we should perpetual trust is better than our trust, which can only last 100 years. But personally, I feel that this 100-year thing is actually a good thing. So when we are trying to promote our trust to my overseas clients, we always face this question of why is our trust better than Hong Kong trust or BVI trust when their trust can last forever? I say lasting forever may not be good, may not be a good thing. Because why we have this 100 years? Because we believe that, unlocking the asset may be a good thing. Because 100 years is not a short period of time. Circumstances may change, right? Situation may change, right? What may be relevant then 100 years ago may not be relevant now. So by having this 100 years, it will actually allow the beneficiary to reconsider whether it is necessary to continue the trust or to collapse to end the trust, right? If they so decide that a trust is relevant at that point in time, they may actually create another trust and continue with the trust. If at that time the beneficiaries think that, well, there is no longer a need for that trust to exist, the trust which was created by their grandfather 100 years ago or their great-grandfather 100 years ago, then basically they will end the trust. So it's actually a good thing to have this 100 years validity period, right? Because it sort of forces the beneficiary and the trustee at that time to look at the circumstances and consider whether the circumstances at that time still warrants the trust, which could be set up 100 years ago, right? So there are arguments for and against this perpetual thing, all right? So this is to illustrate a point why this client actually wanted to do a trust, and he eventually transferred the semi-detached house to the trustee, right? For succession and estate planning, because he really does not want or did not want his family members to be unhappy about his decision. Okay, so family wealth planning for special needs with children. Okay, I want to illustrate this point. In Singapore, you may come across friends or relatives with special needs children. So there is always this concern is that after the parents are no longer around, who is going to look after the special needs children? So we do quite a fair bit of work for families with special needs children. So when we advise these families, right, we will not only talk about, oh, you need to buy insurance, you need to do financial planning, you need to have a will, right? Because and they would have some special requirements, right? For example, I mean, like, it's no point saying that when I pass away, the parent passed away, we give X sum of money to my special needs children, because the special needs children may not know how to manage these funds or this asset themselves. They need somebody, right, to look after them. Okay, so there's always this concern. So we have this organization called the SNT, Special Needs Trust Company, which is a company under the auspices of the MSF, Ministry of Social and Family Development. They are located at Tiong Bahru Plaza. So even our government also set up trust. This is a trust company for family with special needs children. So what the parents can do is that they can go to this trust company and set up a trust account. Minimum deposit $5,000. And this principal sum and whatever money that you put inside this account eventually is guaranteed by the Singapore government. Guaranteed, right? So it is very safe. And of course, they will use this money to invest in some low yield bond, government bond and all this, so that the funds can generate some returns. But what is more interesting is that for this company, they would have special case officer. They are trained in this department, looking after special needs children. So when the time comes, when the parents have passed away, what the case officer will do is to take out the funds from this trust account, right? Come up with a care plan and look after your special needs children. So it is a very interesting concept. So not only do you have this money guaranteed by the Singapore government and protected against creditors, you also have specialized professionals using this money to look after your special needs children, right? So it is again to illustrate why trust is everywhere. Trust is so useful. Trust is so important. And then to supplement this trust, the parents can consider doing a will. And in the will, they can state that, well, when I passed away, I have this insurance policy that I have bought. That's why financial planning is important also, right? When I die, there will be this insurance money that I will pour into this trust account with SNTC. So the SNTC trust account will have this lump sum of money that comes from this insurance company. All right. So you can see the marriage of a will, insurance, and trust coming together for the benefit of the special needs children, right? So I hope I have given you an example of how powerful and useful trust can be. As compared to if there is no trust, you just basically give outright a sum of money to your special needs children. But that may not be ideal, right? Because they may not know how to manage these funds. All right. Confidentiality, again, to illustrate a point. For whatever reason or confidential reason, some clients may not want their name to be revealed. All right. So what they do is that when they come to Singapore to set up a company, for example, right? Some Dato or Tan Sri, from Malaysia, they come to Singapore. They do not want their name to surface for whatever reason. So what they will do is that, for example, they will get me to set up the company. So if you do a search on the company's record, my name will appear as the director and the shareholder. All right. But actually on the site, we have a trust deed to say that I am holding this share in trust for Dato so and so from Malaysia. So the real beneficiary, the beneficial owner of this company, of these shares, is the Malaysian. I am merely a trustee. So when you do a search, Dato's name will not surface. So for confidentiality reasons. Charity, right? People set up charity and the underlying mechanics can be found in trust. Like for example, bursary, scholarship, right? Nobel Prize. Have you heard about the Nobel Prize? Actually, if you go and understand about Nobel Prize, right? Mr. Nobel actually had a will. His will is actually quite simple. 100, he actually had a will, I think it's a one-page will. In his will, he created the Nobel Prize. It was a testamentary trust. That means he actually, in his will, he created a trust that will take effect upon his passing. That was how Nobel Prize was born. All right. And that has lasted like until today, hundreds of years. Right. So he basically invested a sum of money and created the Nobel Prize in his will. All right. So of course, for Nobel Prize, there is a board of trustee who is entrusted with the responsibility of administering the Nobel Prize. And that has gone on for so many years. Okay. So wealth asset protection against creditor. I said this is a common reason why people set up trust, right? They want to ring fence the asset, whatever that you put in an irrevocable trust. Trust again got many types. Now I'm going to the specific, right? You have revocable trust, irrevocable trust, discretionary, fixed trust, so on and so forth. If you want to ring fence your asset, protect your asset against creditor, you can consider putting your assets into an irrevocable trust, meaning that once you have settled or vested the asset into this trust, you cannot take it out. You cannot revoke it. And if you have done this trust for a minimum period of 5 years, whatever assets that you put into this trust is protected against creditors. That means the creditor cannot seize this asset. Okay, this is good for business owners. If they have concerns that their business may fail, and they are personal guarantee to loans and all this, and what is going to happen to their asset. The creditors may come and take whatever they have, and there will be nothing left for their wife or their children. So in the past, what people did is that they transfer assets and park it under their wife's name, their children's name. That is not a very sophisticated way of protecting your asset. A better way, a sophisticated way, is to actually transfer the ownership of your asset into a trust, right? This is a professional way of protecting your asset against a creditor. All right, irrevocable trust. Again, in case you think that this sounds expensive and all this, actually it is not. Just understand the concept. Okay, just understand the concept. For example, you can always ask your husband, go to POSB bank, set up a savings account, put $10 inside, right? So your husband open a POSB account, put $10 inside, and get your husband to sign a trust deed, an irrevocable trust deed, and say that he is holding this $10 in the POSB account as a trustee for the benefit of you, the wife, and your children. Ladies and gentlemen, you have an irrevocable trust already. As simple as that, you know, $10. And every month you just deposit $30, $50 into that account. Once it crosses the 5-year mark, whatever money is in the POSB account, ladies and gentlemen, it is a trust account. It is protected against creditors. Powerful idea. You don't need $10 million to do this. Correct? No? You can start $10, $20. So you need to understand the idea. Once you understand the idea, the law, you will see how powerful it is. And nobody talks about you need to be ultra high net worth client to be able to do this, right? So I am here to clear up whatever misconception that you have. So I hope that by now I have explained to you why trust is so popular, it's so powerful, and so affordable. All right. Sorry. So what are some of the key benefits of having a trust? Powers retained by Settlor. So, okay, this is to go into the specific of a trust, right? Settlor free to reserve to insert any of all the power investment. You know, sometimes when we talk to some of my clients, they are worried. You know, Patrick, you're asking me to relinquish control ownership to a trustee. I don't feel safe. I don't feel comfortable. You know, sometimes we like to control things, right? We like to hold things close to us. We are not, you know, we have this sense of possession that we value a lot, right? So they don't feel comfortable investing all their assets or a substantial part of the asset to this person called a trustee whom they hardly know. So what we can do is to mitigate or balance that concern, right? By reserving some powers to the owner in the trustee to say that, okay, don't worry, even after you have transferred the ownership of this asset to the trustee, you can still have some power to invest, to have a say, right, over how this asset will be managed or administered. So that assure the settlor, the owner, that don't worry, you see, not all is lost. All right, so we can do something. So it's like a best of both worlds. On one hand, you transfer ownership of the asset to the trustee. On the other hand, you are still able to manage, right, or administer the asset to a certain extent. And you can also appoint this person called a protector. This is optional. It's a person called a protector who is appointed to have oversight, you know, oversight of the trust. Basically, it's like supervisor, you know, supervise the trustee to make sure that the trust is administered properly, right? So in case settlor worry again whether the trustee is legit, whether the trustee, you know, will mess things up and all this, he can always consider appointing this third person, third party called a protector. As the name suggests, he is there to protect the trust. All right. So again, this explain how flexible a trust can be, right? No estate duty or inheritance tax. Like I said, once you put into a trust, this happens in Singapore before 2008. Once you vest a property and asset into a trust, it is no longer yours. Since it is no longer yours, it will not be subject to estate duty or inheritance tax. Incidentally, in Singapore, we do not have any more estate duty, inheritance tax, or capital gains tax, for that matter. Okay, but as far as real estate is concerned, I'm sure we all know that we have this thing called the seller stamp duty and additional buyer stamp duty, right? We have these taxes, you know, in Singapore, but we don't have any estate duty or inheritance tax. All right, income tax mitigation for foreign trusts. I say this with a big pinch of salt, caveat emptor, caveat, because in many countries nowadays, even for assets put into a trust, it is taxable. All right, the law has changed considerably over the years. In the past, it used to be a very good instrument to help mitigate taxes. But over the years, many countries are beginning to amend the law to say that even income deriving from trust is taxable, right? So it is becoming less of a benefit, right? In my experience, the reason why people are setting up a trust is really in the rhyme of preserving the asset and protecting the asset from creditor, and also to prevent disputes among the loved ones. Nowadays, this seems to be the primary reasons why people are doing a trust. And also they realize that actually the cost of setting up a trust is not prohibitive. It's not prohibitive in the grand scheme of things. There will be costs, but it is not like it's going to cost you an arm and leg. Okay. So now, what are the different types of trust? As I mentioned earlier, you can actually download my article, right, to have a better understanding of the different type of trust. So we have express trust, meaning trust that is expressly stated in a document, a trust deed, so on and so forth. You can have, of course, statutory trust, implied trust, so on and so on. Discretionary trust, just to give you an example. I give a sum of $100,000 to my trustee. It is up to his discretion how he wants to administer this $100,000 for the benefit of my 3 children. So my trustee has a lot of discretion. As compared to fixed trust, my trustee has limited discretion, meaning that my trustee has to give a sum of $100 every month to my 3 children for their education only, nothing else. That is an example of fixed trust. And other common types of trust we have in Singapore, private family trust. I am sure you have heard of this term called family offices, so on and so forth. It's like quite trendy nowadays. But actually, the underlying mechanism, the underlying structure is what we call a PTC, private trust company. Private trust company, right? Again, as the name suggests, private trust company, the mechanics is in trust, all right? But layman term, we call it family office. Again, I will take another few days to explain to you the benefits of having a family office. But now this seems to be all the trend, right? So we have family offices, we have multi-family offices, we have single family office, we have ultra-rich family offices, they hire lawyers, bankers, and all this to work in their bungalows, exclusively for the ultra-high net worth. Or we also have professional family offices where they actually manage various family offices, so they are professional. But the underlying mechanics in how to carry out these family offices is found in trust. It's called a private trust company. Okay, just to give you an idea. And then statutory trust. We also have this thing, like one example is we have in the insurance context what we call Section 49L, whole life insurance. This is an irrevocable trust insurance policy. Most insurance companies offer this. Section 49L, so it is a statutory trust, it's a legal trust pre-packaged for you by our government under the Insurance Act of Singapore. Section 49L, irrevocable trust whole life insurance policy. It is a policy that you may want to consider. Again, as the name suggests, if you remember what I said, irrevocable trust. Once you have purchased this policy, the benefits must go to your spouse and children directly. And the beauty of this policy is that because it is irrevocable in nature, and once you have bought it, the benefits get assigned to your spouse and children directly, it is no longer part of your estate, meaning your creditors cannot touch. So for businessmen out there, I always advise them to consider taking up one of these policies. If all else fails, if your business tanks, at least you have this policy for your spouse and your children. And then, of course, we have charities, as I mentioned earlier, your bursary, your scholarship, and then you have your collective investment trust, your REITs, unit trust. So these are the common types of trust in Singapore. All right. So how to create a trust instrument? Trust can be created by contract, by will, by deed. By will, meaning we are talking about testamentary trust. By deed contract, you have a living trust when the trust actually takes effect during your lifetime. All right. So I hope that I've given you a nice overview of what a trust is. Like I said, actually I've overrun. The time now is almost 12 o'clock. This session was supposed to take 30 minutes. But you see, there's so much to share. And even after almost an hour, I don't think I have shared even 10%, on trust with all of you. I just hope that I have given you a very nice broad overview of what trust is. And of course, if you want to find out more or to learn more, or if you have clients or yourself, who is interested in this, please talk to us, consult. For our law firm, we have two practice groups: private client, which I am heading, and corporate client. So as you can see, under private client practice group, I do trust, I do estate planning. Actually, I do it quite a lot, right? So again, if you yourself or if you know of any clients, local and overseas, who wants to know more about setting up a trust or a will in Singapore, please talk to us. My contact detail are here, and also I have a team. I do not work alone, so these are members of my private clients team. So I Berlin, Andrew, and Jacqueline, my business development manager. We have two offices, one at Raffles Place and the other one at Jurong. I would also strongly encourage you to like us on Facebook and our LinkedIn, because we do quite a lot of this free webinars nowadays. So you can be updated on the latest schedule, and so that you can come on board and learn more. All right. So thank you very much for staying with us until now. This is a time where I would invite questions, if you have, on whatever I share with you today. Okay. Now let me see the group chat, see whether there are any questions. Is it under a trust? It is not complicated. Power of sale is a common power that a settlor gives to a trustee, right? I mean, ideally, we should have the power to sell stated clearly in the trust deed. So if you want that power, please tell your lawyer to put that power to sell in the trust deed. Otherwise, the law actually also gives trustee the power to sell, right? The law, actually, our trustee actually accords such power to sell, or the case law, I would say, sorry, give our trustee the power to sell, right? So if you want to have the power to sell to be given to your trustee, then please state it clearly in the trust deed. So if it is stated clearly, then basically the trustee has the power to sell. It is not complicated at all, right? So if the trustee sell the property, then of course we have to make it clear also the sale proceeds, who would it go to? Of course, the beneficiary, right? After you sell, there will be money. So where would the money go to? Who would it benefit? So all this must be stated clearly. If it is not stated in the trust deed, then what they can do is to apply to court also. The trustee can apply to the court to ask for this power to sell. And of course, the trustee has to convince the judge why it is necessary, right? Can the settlor and trustee be the same person? Yes, of course, can. It is very commonly done. Okay, this is the detail. Nowadays, a lot of people are going to show flat to buy property in trust for their son, daughter, nephew, nieces, right? So the parents, they are the settlor because they buy. They are also the trustee for their children. It is very common in show flat now. A lot of people are going in to use trust to buy. Why? Because they want to buy the asset, lock in, because their children are too young to buy the property. But they like the property a lot. They want to buy it for their children first. So they use trust to go and buy. So when their children turn 21, they will transfer the property to their children. So this is how trust actually comes into play in real estate context. If you like what you hear, actually, I do have a course. In fact, I just did a course on this. It's a 1.5-hour course early this week, where I talk about how we can use trust to acquire real estate. It is a 1.5 hours course. I'm not sure when is the next run on this course. Maybe Jacqueline can share later on. We may consider having a next run where we actually talk about trust in the real estate context. Does the injection of an asset into a trust subject to SSD? Yes, any divestment, right, of an asset into a trust will attract stamp duty. All right, will attract stamp duty. Seller stamp duty doesn't mean you sell, then you have to pay. The law is not to sell, the law is to divest. So I always share with a lot of people, don't be caught up by this word seller stamp duty or buyer stamp duty. The law is actually very wide. It talks about divestment and acquisition. So divestment of any form, like for example, of trust, through the method called trust, will attract SSD if it is divested within 3 years of your acquisition. And the person receiving the trust asset may also be liable for stamp duty, buyer stamp duty. All right. So this is the asset. My colleague has actually put up a link. So if you have a trust, do you still need a will? Of course. Like I said, you can have a trust built inside your will. It's called a testamentary trust. Or you can have a living trust that is apart from your will. So will is a will, living trust is a living trust, right? For whatever reason you want to do a living trust. Or you can actually put a trust into your will that is called a testamentary trust. So you have a will which has incorporated some elements of a trust. Also can. As to the fee, right, you need to talk to my colleague, let them know your requirements, then they will be able to advise you. Normally for testamentary trust, right, it's not expensive. A will is like $300, then you plus a testamentary trust thrown in. They have packages. You want testamentary trust for your wife, for your parents, for your children. They have different packages, $150 to $200. They can package in this testamentary trust for you. Okay, thank you. Half know about trust. Thank you, everyone. Standby trust. Okay, there's a question on standby. As the name suggests, it is on standby. So the trust you can create now, but it is empty, right? But the trust is on standby. When will it take effect? Is when you pass away. So your will basically pour over maybe your insurance money into the standby trust which you have created 10 years ago when you were alive, right? So standby trust, as the name suggests, you create right now, but it doesn't take effect right now. You create the trust right now and put it on standby. Okay. Also, property under trust when sold. Does beneficiary need to pay taxes? So it is the same. Stamp duty wise, if the trustee has the power to sell and in fact sell the property, right, then the income actually go to the beneficiary, right? So then the question is whether there are certain tax trust income benefits under Singapore law. I'm not talking about US and all this. Under Singapore law, there are certain benefits. Again, it will be quite taxing. Okay, sorry for the pun to go into the detail, right? So different countries, they have different treatment to income deriving from trust or from the sale of a trust asset to the beneficiary. Different countries, they adopt different tax treatment when it comes to this. But for Singapore, we do have certain tax benefits. To answer your question, Bill. Reopening of bank account under trust. If the 5-year cut off again counted from date bank account, yes, from the date the account was opened. And of course, you want to be detailed about it, right? I know what you mean. You know, you could be starting this bank account with $10. Then later on, 1 week before your bankruptcy, you put like $500,000 inside. Basically, at the end of the day, the creditors, the judge will look at the intention of the settlor. Is your intention legit, or is your intention trying to defraud the creditor? That is the question. All right. So although I said that you can do a monthly installment, right? The question, Michelle, you asked is that, well, from the creditor's point of view, when would the 5-year apply? Of course, if the large sum of money was deposited into this trust account 2 days before the bankruptcy, then I would think that the protection will not be given to you. It is, in fact, an act to defraud the creditor. So I always advise my client, if that is your intention, better start as early as you can. Plan well ahead. Put as much money as you can in this trust account, right? So if let's say you have $1 million or 300,000, you may straight away want to put 100,000 into a trust account. 200,000 you can put it in your own pocket. But at least if all else fails, you have $100,000 protected against creditor, right? Basically, don't put all your eggs in one basket. Okay, any other questions? Okay, I've done those on the group chat. Do you have any questions on Facebook Live? Sorry, I haven't been looking at my Facebook Live. I don't think there are any questions on Facebook Live, right?
Yeah, there are none. There are none for now.
All right, then. Thank you very much for joining me. I hope that you have a good day ahead and a good weekend coming up. Jack, over to you.
Yes, thank you everybody for your time. And I think it was definitely a very informative session with Patrick. And the info he shared really comes from his years of experience. So really do contact us if you need anything on your estate planning needs, and have a lovely weekend. Thank you, everybody. Thank you.